Before I get into the private side, I'm going to read a couple of little things real quick just to kind of clear the air with a few of you people that don't know. So, Title 18, Part 1, Chapter 2, found at 31, Definition 6, Motor Vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property and or property or cargo. The highways are for the use of the traveling public, traveling public, and all have the right to use them, in a reasonable and proper manner. The use thereof is an inalienable right, inalienable right of every citizen. You can find that in the case Escobedo versus the state, 35 C2D 870 in 8 Cal jurisprudence, 3rd, page 27. The use of the automobile is a necessary adjunct to the earning of a livelihood in modern life. And requires us in the interest of realism to conclude that the right to use an automobile on the public highways partakes of the liberty within the meaning of the constitutional guarantees. You know that 10th Amendment you was always talking about, Ben? That 10th Amendment gives us the same power that it gives the state. Berberian versus Lusser, 1958, 139, A2D, 869, 872. Listen to this, Ben. That power of the 10th Amendment, check this out. The right of the citizen to drive on the public street with freedom from police interference unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by the courts. People versus Horton, 14 Cal, Appel 3rd, 667, 1971. A U.S. citizen, upon leaving the District of Columbia. Interesting that this is a California case mentioning the District of Columbia. Becomes involved in interstate commerce as a resident does not have the common law right to travel of a citizen of one of the several states, meaning once you come out of the District of Columbia, you are interstate commerce no matter what state you're in. Ben, since you seem to think you know the law, well, Ben, there's the law right there, Ben. Hendrick versus Maryland. Oh, one of the phrases you forgot to mention in the case, Ben. Again, as you do always. Hendrick versus Maryland, SC Reporters RD, 610, 625, 1914. One who drives an automobile is an operator within the meaning of the Motor Vehicle Act. You might want to go check the statutes on that Motor Vehicle Act, Ben, because they're all commercial. Okay, so Pontius versus McLean, 113, California, 452. The word operator shall not include any person who solely transports property and who transports no persons or property for hire or compensation. Statutes at large, California, Chapter 412, page 833, the right of a citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and the pursuit of happiness. Slusher versus Safety Coach Transit Company, 229 Kentucky, affirmed by the Supreme Court in Thompson versus Smith. You know that case you say doesn't say that? It was actually confirmed in Thompson versus Smith, buddy. 154 Southeast 579. Also see Edwards versus California 314 U.S. Supreme Court cases. Twining versus New Jersey 211 U.S. 78. Williams versus Fears 179 U.S. 270 at 274. Crandall versus Nevada 6 Wall 35 at 43 and 44. The passenger cases 7 Howard 287 at 492. U.S. versus Guest 383 U.S. 745 at 757 758 1966. Griffin versus Breckenridge 403 U.S. 88 at 105 106 1971. Califano versus Torres 435 U.S. 1 at 4 note 6. Shapiro versus Thompson 394 U.S. 618 1969. Califano versus Asnavarian 439 U.S. 170 at 176 1978. And it's interesting because every single one of those cases are United States Supreme Court cases affirming the right to travel. What? And you people better wake up. So anyway, we're going to get into let me see if I can find it here. There we go. Oh, by the way, these are straight from the book, not Google, by the way. Shapiro versus Thompson, 394 U.S. 618, April 21st, 1969. Ben, listen to this very carefully, Ben, because this is your 10th Amendment again, Ben. Further, the right to travel by private conveyance for private purposes upon the common way cannot be infringed. No license or permissions is required for travel when such travel is not for the purpose of commercial profit or gain on the open highways operating under license in commerce. The rights of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of the government. Sinez versus Roe, 1999. And you know what's interesting about that Shapiro-Thompson case? The very last phrase of that statement that I just read is the exact same phrase that was used in Hale versus Henkel. The very last phrase of Hale versus Henkel says, in the number of times it has been Hale versus Henkel, in the number of times it has been cited by the courts, the rights of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of government. That exact same phrase found in that Bourne case, that case that actually made everything possible. Hale versus Henkel, 201 U.S. 43 at 89, 1906. Interesting that a case, Shapiro versus Thompson, 394 U.S. 618, April 21st, 1969, says the exact same thing as a case damn near 100 years prior to his existence says. Huh. Imagine that. Porter versus State, 391 Northeast 2D 801, 808, 809. When governments enter into the world of commerce, they are subject to the same burdens as any private firm or corporation. U.S. versus Burr, 309 U.S. 242 C22 USCA 286E. Bank of U.S. versus Planners Bank of Georgia, 6L-ED 9 Wheat 244 22 USCA 286 ETSEQ CRS 1160-103. Let's see, what else can we get into? City of Dallas versus Mitchell, 245 Southwest 944. To take away all remedy for the enforcement of a right is to take away the right itself, but that is not within the power of the state. Poindexter versus Greenhow, 114 U.S. 270 303 1885. Brady versus United States, 397 U.S. 742 748 1970. Waivers of constitutional rights, not only must they be voluntary, they must be knowingly intelligent acts done with sufficient awareness. Carnley versus Cochran, 369 U.S. 506 516 1962. Presuming the waiver from a silent record is impermissible, the record must show, or there must be an allegation and evidence which show that an accused was offered counsel but intelligently and understandably rejected the offer. Anything less is not a waiver. Okay, so now what I'm going to do is I'm going to go into why officers should know their place. Okay. Trazevant case damage award standard. Evidence that motorist cited for traffic violation, who was then incarcerated for 23 minutes during the booking process, even though he had never been arrested and at all times had sufficient cash on hand to post a bond pending court disposition of citation, was sufficient to support finding that the municipality employing officer who cited motorists and County Board of Criminal Justice, which operated facility in which motorist was incarcerated, had unconstitutionally deprived the motorist of his right to liberty. 42 U.S.C.A. Section 1983, Traswick versus the City of Tampa, 1984, 741 Federal 2nd, 336, Head Note 1. Jury verdict of $25,000 in favor of the motorist, who was unconstitutionally deprived of his liberty when incarcerated during booking process following citation for traffic violation, was not excessive in view of evidence of motorist back pain during period of incarceration and jailer's refusal to provide medical treatment, as well as fact that the motorist was clearly entitled to compensation for incarceration itself and for mental anguish that he had suffered from entire episode. 42 U.S.C. Section 1983, Trasvet versus City of Tampa, 1984, 741 Federal 2nd, 336, Head Note 5. Maddock versus the United States, 156 U.S. 237 243 1895. We are bound to interpret the Constitution in the light of the law as it existed at the time it was adopted. Well, well, well. There's that. So, private side. Shapiro versus Thompson. I love that. Further, the right to travel by private conveyance for private purposes upon the common way cannot be infringed. There's the power of the 10th Amendment right there for you, Ben. Oh, I'm reading it straight from the book too, Ben, not off Google. And in the event that all my haters, traitors, and trolls are trying to figure out who Ben is a cop from out of Ohio. Ben seems to think that he knows the law, but Ben doesn't understand that the 10th Amendment that gives the state the power to regulate also gives the people that exact same power. Nowhere in that amendment does it just say the state. At the end of that amendment, it also includes or the people. Or to the people, it says, actually, word for word. Or to the people, it says. So that does not exclude one, okay? Because the Latin legal maximum, that which is not included excludes all others, doesn't apply because of the simple fact it does include the people. So it gives the people the exact same equal footing as it gives the state. Hence the reason why people, the people, me, the people, Dark Angel, me, the people, have the authority to self-govern. Self-govern, self-regulating, right? It's regulating. I self-govern. Can't deny it, can't dispute it. Facts. It doesn't say that it gives the state the power to do it and it doesn't give the people that same power. It doesn't say that in that amendment, in the 10th Amendment. It says, let me read it to you so you understand what the 10th Amendment says. Because apparently you dummies out there seem to think you know the law and you don't know shit. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Did you catch that last part? Or to the people. It doesn't say it's just given to the states and that's it. It's given to the state or the people, either or. It doesn't say that, well, if the states get it, the people don't. If the people get it, the states don't. It doesn't say that. It says the states or the people. It's letting you know who can have it. The states can have it or the people can have it, either or. Sorry. Facts. Can't dispute it. Been trying to tell you guys this for the longest time, but none of y'all seem to it seems like to me every time one of you mention the 10th Amendment, you always leave the people part off of the amendment. You always read up to the state part and that's it. And you don't see the other 4 words that's left on the back of that amendment. See, you're so stuck on your program that you fail to identify as the people. Hence the reason why you are a citizen, a slave to the corporation. You know, and maybe one day you'll wake up and realize that the term sovereign citizen is clearly an oxymoron. A sovereign is a master, a king. A citizen is a slave. Go back and do some history on the term citizen. As I said earlier, Citizen Kane, it was about a slave, you know? Yeah. Anyway, this is Dark Angel. Hope y'all had a good day. This was the constitutional Supreme Court cases, some that cases are all standing law to this day. And I'm not even going to tell you guys where I got it from because you guys are going to have to do your own homework. But I'm going to just let you see that, well, I'm not going to let you see because I'm not going to show it to you. But one thing I will say is this before I close. So I want to make sure that everybody knows this, because I'm going to read a couple more cases for you real quick. Bennett versus Bogg, First Baldwin, 60. Statutes that violate the plain and obvious principles of common right and common reason are null and void. Would we not say that these judicial decisions are straight to the point that there is no lawful method for government to put restrictions or limitations on rights? Did you hear that? There is no lawful method to put restrictions or limitations on rights belonging to the people. Other cases are even more straightforward. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of practice. Davis versus Wechsler, 263 United States, 2224. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. That's interesting that they should say that in that case, because that exact same saying is found in Miranda versus Arizona. Miranda versus Arizona, 384 U.S. 436, 491 says the claim and exercise of a constitutional right cannot be converted into a crime. Miller versus U.S. 230 Federal, 486, 489. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. So, Shearer versus Cohen, 481 Federal, 946. We can go on quoting court decision after court decision. However, the Constitution itself answers our question. Can a government legally put restrictions on the rights of American people at any time for any reason? The answer is found in Article 6 of the United States Constitution. Miranda versus Arizona, 384 U.S. 426, 491, 86 Supreme Court, 1603. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. That's interesting that, again, Davis versus Wechsler, Miranda versus Arizona has the exact same phrase written within the opinion of the case. Which would tell me, Ben, those are standing law. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton versus Shelby County, 118 U.S. 425, page 442. Simmons versus United States, 390 U.S. 377, 1968. The claim and exercise of a constitutional right cannot be converted into a crime. A denial of them would be a denial of the due process of law. Whoops. Well, Cooper versus Aaron, 358 U.S. 178 South Supreme Court, 1401, 1958. Any judge or officer who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge and or officer is engaged in acts of treason. The U.S. Supreme Court has stated that no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. Also see this found in these several cases. Henry Sawyer, 124 U.S. 200, 188. U.S. versus Will, 449 U.S. 200, 216, 101. Supreme Court, 471, 66. Cohens versus Virginia. Oh, my goodness, my goodness. Let's see, Cohens versus Virginia, 19 U.S. 6 week, 264, 4045. Limited edition, 257, 1821. Hofsommer versus Hayes, 92, Oklahoma, 32, 227, Federal 417. The courts are not bound by an officer's interpretation of the law under which he presumes to act. Let me cite that again for you, Ben. Hofsommer versus Hayes, 92, Oklahoma, 32, 227. Excuse me. Federal 417. The courts are not bound by an officer's interpretation of the law under which he presumes to act. Excuse me again. Damn. So, there we go. It is interesting. 14th Amendment is a bad son of a gun. Marbury versus Madison, 5 U.S. 2 Cranch, 137, 180, 1803. Listen to this, Ben. The particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. In declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. All laws, rules, and practices which are repugnant to the Constitution are void, since the 14th Amendment to the Constitution states, "No state jurisdiction shall make or enforce any law which shall abridge the rights, privileges, or immunities of citizens of the United States, nor deprive any citizens of life, liberty, or property without due process of law or equal protection under the law. This renders judicial immunity unconstitutional." Oopsie. Constitutional Supreme Court cases right here, Ben. Hang on, Ben. I got another one for you. Shower versus Rhodes, 416 U.S. 232 94 Supreme Court, 1683, 1687, 1974. Note: by law, a judge is a state officer. The judge then acts not as a judge but as a private individual in his person when he acts as a trespasser of the law. That same rule applies for police officers, Ben, in the event that you didn't know that. Yeah. When a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are not voidable, but void, and of no legal force or effect. The U.S. Supreme Court stated that when a state officer, which would be you, acts under a state law in a manner violative of the federal Constitution. Wait. Did you hear that, Ben? Did you hear that, what it said there? State law in a manner violative of the federal Constitution. State Constitution, federal Constitution. Federal governs the state, Ben, because you seem to not understand that. You have to come in compliance with the feds. Feds don't got to come in compliance with you, the state. You have to come in compliance with the feds. Period. You're governed by the feds. Period. He comes into conflict with the superior authority of that Constitution. And he is, in that case, stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. Whoopsie. Anyway. Oh, here you go. Murdoch versus Pennsylvania, 319 U.S. 105. No state shall convert a liberty into a license and charge a fee therefore. Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. If the state converts a right liberty into a privilege, the citizen can ignore the license and fee and engage in the right liberty with impunity. Oh, and I remember you was talking about some of these cases. They worded it this way. What you fail to understand, Ben, is it doesn't matter what the case is about or what it pertains to. And for some reason, a lot of you haters, traitors, and trolls seem to think that, oh, that case is not in reference to the right to travel. It doesn't have to be. It's in reference to a license to do something. And a license to drive fits that criteria. It's a license to do something. You're asking for permission to do something. So the rule that is mentioned within the Shuttlesworth versus City of Birmingham, Alabama, if the state converts a right liberty into a privilege, the citizen can ignore the license and fee and engage in the right liberty with impunity. You get it now? Doesn't matter what the case is about, Ben, and all you other hater, traitors, and trolls. It's about the subject matter of what the case is addressing. The case is addressing a license, regardless as to what the license is for. It's talking about a license. I don't even know how more simply that can be put. It's clearly addressing the issue of a license. It doesn't matter what the license is for. A license is a license is a license. Definition of a license is the same all the way around the board. Period. Brinegar versus U.S. 388 U.S. 160 1949. Probable cause to arrest provides details on how to determine if a crime has been or is being committed. Shuttlesworth versus City. Oh, I read that one already. No, never mind. But yeah, I want you to keep these cases in mind, you guys, because a lot of people seem to think that these Supreme Court cases don't exist. Oh, and here's to a lot of you people who don't know. So I'm just going to hit this real quick. Elmore versus McCammon, 1986, 640 Federal Sup 905. The right to file a lawsuit pro se is one of the most important rights under the Constitution and the laws. Haynes versus Kerner, 404 U.S. 519 1972. Allegations such as those asserted by a petitioner, however inartfully pleaded, are sufficient, which we hold to a less stringent standard than formal pleadings drafted by lawyers, meaning that as long as you cite that case in your brief, you do not have to come in compliance with the way a actual lawyer writes a brief. You could write your brief on toilet paper. The courts have to accept it. Okay? You can write your brief and make your claims on toilet paper, and they would have to accept it. Period. End of story. That case right there, Haynes versus Kerner, says so. I've used that case in the past. Let's see. Jenkins versus McKeithen, 395 U.S. 411 421 1959. Picking versus Pennsylvania Railroad Company, 151 Fed 2nd 240. Puckett versus Cox, 456 2nd 233. Pro se pleadings are to be considered without regard to technicality. Pro se litigants' pleadings are not to be held to the same high standards of perfection as lawyers. Right there you go. I just said that with the Haynes versus Kerner case. Put both of those in your brief. Talk away. Puckett versus Cox, 456 Fed 2D 233 1972 6th Circuit USCA. United States Supreme Court of America. It was held that a pro se complaint requires a less stringent standing reading than one drafted by a lawyer per Justice Black and Conley versus Gibson. See case listed above, pro se rights section. Boy, oh boy, oh boy. Oh, here you go. Here's to all you people who think you need a license to practice law. Sims versus Hearns, 271 Southwest 720 1925. The practice of law is an occupation of common right. Because of what appears to be a lawful command on the surface, many citizens, because of their respect for what appears to be law, are cunningly coerced into waiving their rights due to ignorance. Well, there you go. And I've been saying that all along. There ain't no such thing as a lawyer having a license. There ain't no such thing. You don't need no license to do things. It just tells you right there. Because of your ignorance of not knowing that you don't actually need a license to do something, that's why you lose. Sims versus Hearns, 271. There you go. Let's see, what is this one? U.S. versus Menker, 350 U.S. 179 at 187, 1956. Supreme Court of the United States of 1795. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality or substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. Meaning they can't even contract with a private individual. They can only contract with your straw man, all caps. Yeah, so there you go. Donnelly versus De Cristoforo, 1974 Supreme Court at 41709-56. I'm not even going to get into that. Fraud, in its elementary common law sense of deceit, includes the deliberate concealment of material information in a setting of fiduciary obligation. A public official is a fiduciary toward the public, and if he deliberately conceals material information from them, he is guilty of fraud. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. Hagens versus Levine, 415 U.S. 533. A judgment rendered by a court without personal jurisdiction over the defendant is void in its nullity. The law provides that once state and federal jurisdiction has been challenged, it must be proven. And that can be found in Shermeck versus Shermeck. 17 Kansas Appeal, United States, 2D, 573, 576 at 7, 840, page 553, 1992. Reverse denied, 252 Kansas, 1093, 1993. Okay? Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Maine versus Thin Bouttopt, 100 Supreme Court, 2502, 1980. Once challenged, jurisdiction cannot be assumed, it must be proved to exist. Repeating the exact same thing I just said before. Bassel versus Utah Power and Light Company, 395, Federal 2D, 906, 910. And, later on we'll get off into the corpus delicti and all of that good stuff, because all these haters, traitors, and trolls and all that, they seem to think that none of this, what we're talking about, exists. I'm going to tell you why they say that. They say that because they've never actually heard of these cases. And when they heard of the cases, all of a sudden it was the sovereign citizen. Goes to show you their intelligence that they have, calling someone a sovereign citizen and not even knowing the actual definition of the two words. Go figure. Who would have thunk that, they were that intelligent that they could put two words together and make a word: sovereign citizen, a king and slave. Go figure. I'm just saying. So, if anybody ever addresses you with the expression sovereign citizen, take it for face value that they know nothing, because they don't. They don't know nothing. If they're calling you a sovereign citizen, don't even pay them no mind, because it's clear that they have no idea what a sovereign citizen is. You can't be a master king and a slave at the same time. Can't do it. Can't happen. Can't be a king and a slave. Unless you're a captured, conquered king and you're being held captive. Dark Angel, Audi.